afternoon. You can be seated. And the matter before the court is York 24-548, Mark Moriarty versus the town of Eliot. We are being streamed on the web, both by audio and video. If counsel would identify themselves by saying their names for the record, together with the party you represent, starting with the appellant.
Good afternoon. My name is Patrick Bedard. I represent Mark and Kathleen Moriarty, the appellants.
Madam Chief Justice, Grady Burns for the town of Eliot, the appellee.
Thank you. And Attorney Bedard, if you're ready to proceed, we'd be happy to hear your argument this afternoon.
Thank you. Good afternoon, Madam Chief Justice, members of the Supreme Court. May it please the court, my name is Patrick Bedard. I represent Mark and Kathleen Moriarty. They reside at 324 Goodwin Road in Eliot, Maine. Mark Moriarty is a licensed electrician, and this case involves a home business that he applied for his home at that location in Eliot, Maine. Sometimes I'll slip and call it a home occupation. He was denied by the LA Planning Board. We believe that he met all the criteria necessary for a home business at that location. After the denial, he appealed to the Zoning Board and the York Superior Court, both of which denied his appeal. So there seems to be two central issues in this case, one of which centers around the Planning Board's use of a preamble in the definition of home occupation as an additional criteria to deny Mr. Moriarty. The preamble essentially says that the intent of the home business is that businesses be allowed if they're in a scale or in character consistent with the use of the zone. This is a rural zone. The Planning Board incorporated that into their findings of fact. The Superior Court relied upon that as well, and holding that they were correct. The Planning Board was within its discretion to find they didn't meet that.
I see that the green light is on, and when you say that that is only in a preamble, which portion of the code are you looking at?
So I'm on page 99 of the appendix.
Yep.
The beginning of 45-456.1.
So it's the first paragraph under that section, correct?
Yes.
But when the code defines home business on page 59 of the appendix, and that's how it gets to there, right? You start at page 59 and it defines a home business. Doesn't the board get to define whether this is a home business?
Not when the definition then says you need to meet this criteria, and when these criteria are all clear.
Well, it says home businesses means uses that provide space for commercial activity that is in scale and character with neighborhoods and areas that are primarily residential. Home businesses must comply with the requirements. So doesn't that impose both of those things? A, this is the definition, and B, it must comply with the requirements of home businesses under section 45-456.1.
I don't believe
that definition is in both places.
It is, but I believe that on the definition of home business, when it lists all the criteria out, after this, what I have called the preamble and believe is.
No, you're calling it a preamble. That's the question.
It shows up in the definition, but it shows up at the beginning here.
But it also is the very definition of a home business.
It is, but if you look at what the town of Eliot asked people to fill out, their own interpretation of that would not include that as one of the standards. If you go to pages 150 to 153 of the appendix, it lists out what you must meet.
But isn't that because it's not one of the standards it must meet? It is the definition of a home business.
But it's the criteria. It's not part of the criteria. It's not part of the standard that they need to meet. If it would have been, then the Eliot Planning Board should have indicated under the home business checklist, the first item, how's this going to fit with the scale and character with neighborhoods? How's that going to be met?
If somebody wants to put in a grocery store, and it in fact meets all of that criteria, they don't get to inquire that it's not really a home business.
I believe that, yes, and I've made another argument that it delegates legislative authority. If you strip all these criteria away and just define it as that, there's no way to know what scale and character means. I mean, scale of a use in zoning means size. It means how many square feet. It might mean how much product you produce, how much money you obtain. Those kind of things would be scale. There's no way for a planning board to determine that. It might allow a 3,000 square foot use one week, deny a 1,000 square foot use the next week. So it's legislative authority. If you don't, these are so clear in these criteria that there's no doubt what was intended. Character is the same thing, even harder to define than scale. Character is like the type of use. What's that going to be? Are you going to allow a daycare, not allow a grocery
Isn't the
store?
type of use the very first question always?
It is, and that's something we're going to, I assume we're going to talk about, professional office. But yes, they have to meet a permitted use for that zone, or they have to justify to the planning board that it's like another accepted use, and the planning board allows them to do it.
And isn't that the first question that the planning board has to address? What is the actual nature of this use?
Yes, and my client indicated on page 151 of the appendix, it was asked that question by the town and said yes, professional office.
I understand your client said that, but isn't that a fact question for the planning board to determine what is the nature of the use? If I come in and I say it's a professional office, but it's really a grocery store, aren't they entitled to make that determination?
They are if it's that black and white. If it is a situation where an electrician...
Doesn't that then become a question of whether the evidence supports the conclusion that it is or isn't?
So I think the planning board can always make that determination. It's a Trojan horse. You know, you're coming in and asking for an electrical office, and you're really trying to set up a grocery store, and you know you can.
But isn't that exactly what they did here? That you're coming in asking for a professional office, and what you really want is equipment storage and a warehouse?
That is the way they attempted to recast it and justify it, although they went in a lot of other different directions from the findings of fact. But yes, they attempted to do that. The problem with that is, as a kind of a side use or corollary or accessory to any professional office, is going to be equipment storage, because it's defined so broadly in the code, it includes anything. I go to page 51, 3 or more means holding, leaving, or placement of goods, materials, or 3 or more trucks with the intention of retrieving them at a later time. I mean,
Right.
every professional
3 or more
office...
really applies to the trucks, doesn't it?
Well, it may, but anytime you have I agree with that. I think anytime, though, you have a professional office, you can say that. I mean, you go to my office, I happen to be in Eliot, I'm not in a zone where I need a professional occupation or professional business, but somebody could go in and say, we have a bunch of copiers, you have a bunch of things there, and you come get them at various times, and your storage is taking up, you know, 2,000 square feet, maybe 300 or 400 or 500 square feet. We're going to recast you into equipment storage. We're going to ignore the fact that you're practicing law.
But you're actually utilizing the equipment that's in your office. It's
Yes.
it's not sitting there to be moved someplace. It's not sitting there in order for it to be available when you need to use it off-site, is it?
Well, it's there for when I need it for my business.
As part
Same
of your
as an electrician.
ongoing business.
Yes, as part of my business. As part of the electrician's business, they're going to have wires, they're going to have fuses. In this case, they do a lot of generator work. So they're going to have it there, and they're going to take it to where they install it or where they do the actual work.
So it's inventory supply as opposed to the uses that would be more commensurate with a professional office.
Yes, but
It's a
equipment
supply
storage is
company.
defined to be anything, pretty much. Equipment, inventory, you name it. It's very broad.
But isn't there a distinction between, you know, your law office, you've got your copier, you've got your all the other stuff there. You're going to use, it's not going anywhere, but an electrical supply company or electrical contractors keep a lot of stuff, particularly if they're installing big generators, if they're installing conduit and things like that. It's a warehouse where product is being stored, trucks can be coming and going to take it out. Isn't there a distinction between a true professional office and a service company like an electrician or a plumber or something else? I think that's where the planning board looked at it and said, you said professional office. We're saying warehouse and an outgrowing inventory for installation.
That is what they claim to do.
Right.
If you kind of parse away all the other things they went back and forth on, there's some evidence that that's what they tried to do or they did. The problem with that is that the proper approach to this is to say, yes, which the planning board did admit, you're a professional office, you're entitled to have some things there. The town planner recognized that. I mean, others have recognized that. You should allow the permitted use. It is conditional. A professional office is permitted, and your answer should be, you're allowed to do this. Here's the restrictions. We're not going to let you store certain things there. We're not going to let you do things that you might otherwise think you can do, and that's how we're going to limit you. That's a proper answer. The planning board's basic answer was, well, it's too busy. The code enforcement officer is too busy to kind of figure out whether you do
Your
this.
clients are running an electrical contracting business out of their home.
Yes.
They're not, the home really has nothing to do with it. It's a place, it's a base of operations for an electrical contracting business. I mean, if I was a next-door neighbor, and when you live next door, we got a swimming pool, we got stuff around there, and there's trucks coming day and night hauling conduit out of there, and they're backing up there. It's a whole different, it's not with the scale and the typical setting of the residential office. I'd be upset if there was an electrical contractor operating out of next door to me in my residential neighborhood.
You talk
Counselor,
about being professional, but the reality is that as a lawyer, you practice your profession at that location. As a doctor, you practice that profession at that location. The electrician doesn't practice his or her profession at that location. The profession is, assuming it's a profession, is practiced elsewhere.
Well, under the definition of professional offices, it includes anyone who's licensed or needs training to do that. Eliot does not separate out mechanics, doesn't separate out plumbers, it doesn't separate out surveyors, landscapers.
Can I ask you this? You agree that equipment storage, as defined in the code, is not a permitted use?
In this zone, correct.
In this
yes.
zone. So the issue really comes down to whether the facts found by the planning board support its finding that this would be, is being used for equipment storage. Is that right? Is that what this comes down to?
I mean, essentially it does. They denied this, saying professional office and equipment storage is not allowed. This was actually defined and clarified, and I can point in the record to professional office.
If we conclude that the record supports the board's finding that this property, this use is going to be for equipment storage, then we affirm, don't we?
If you find that there's no professional office that's going to be there,
No, if we
I
find
agree.
that this building, or whatever it is they're proposing to build, is going to be used for equipment storage, that's not a permitted use, is it?
Equipment storage or storing what you use as an electrician is acceptable as part of a professional office.
But this
That's
is
the
part
problem.
of but this is part of the factual finding, isn't it, that the board has to make?
I think the only way you can support the board in that instance is to find that there's no professional office there, and it's all equipment storage, period. Because, I mean, my clients did say professional office and equipment storage, but they later clarified it was professional office. There is a professional office there. The way to handle that is the way it was attempted to handle by the town planner and the zoning board, at least with one motion, which is limit the storage, if that's what you think this is going to turn into storage. But if part of this is a professional office, I don't see how you can deny it and then say, well, we determined, because you can determine my law office. I know you wouldn't think so, but you could determine it's storage of product and equipment.
Well, didn't the planning board, in effect, limit the storage by saying you can have a professional office, but the storage for your business needs to be somewhere else?
They did not do that. They could have done that. That's what they should have done. They should have said professional office, and we're not doing anything else. You see in their findings, they think, well, the code enforcement officer is not going to be able to figure this out, so we're not going to allow you to do a professional office. They met all the criteria for that. They should have allowed the professional office. I think the first discussion is not, what I call the preamble, is not a criteria because, well, it would delegate legislative authority as well because there's no way to define that. So it's clear they've given the criteria. My client met it. They should have granted the professional office. They could have said, yeah, you're not allowed to store equipment there. We didn't have any problems if they did that. But you can't just deny my client if they meet the professional office standard. Thank you.
Thank you. Counsel?
Madam Chief Justice, may it please the court. This case the appellant's arguments here really beg the question of whether an applicant can dictate to a reviewing board or to a reviewing court the actual nature of the use being considered in that application. Because the applicant does not have that authority to strong-arm a reviewing board to determine that a given use is in fact a use as defined in the ordinance, that responsibility continues to rest with the planning board, the reviewing authority, and with the courts. And the applicant does not have the authority to essentially strong-arm that determination. The planning board concluded that the proposed use was closer to a prohibited equipment storage than a potentially permittable professional office, and found that that proposed scale and character of the use went beyond what may qualify as a home business. The appellants challenged both of the board's conclusions, arguing on one hand that the board impermissibly recharacterized the proposed use from a permitted use to a prohibited one on one hand, and then on the other that the board impermissibly relied on a precatory or preamble language as a substantive standard. As the Chief Justice pointed out, the precatory language that the appellants are pointing to, or apparently precatory language, is in fact the verbatim definition of a home business in the town of Eliot. The planning board was required as a threshold determination to determine whether the proposed use met the definition of a home business, as that was in fact what was the use that was being applied for. Additionally,
I do see that the green light is on. Can you point me to which, I'm not trying to be opaque about this myself, but I'm looking at the planning board decision, and it's a little hard for me to discern what the basis of decision was.
Sure. So the board's decision has a couple of conclusions and then a series of factual findings. So specifically, the board concluded, and I'm looking at Appendix 23, that per Section 45-290, Table of Permitted Uses and Prohibited Uses, a home business, equipment storage, trucks, 3 or more, is not a permittable use in the rural zoning district.
Is equipment storage, trucks, 3 or more, a home business? Aren't those two different?
So the
Home
mechanics.
business is a permittable use.
So the mechanics here require first a determination of the nature of the use itself. A home business is a specific subset of uses within the ordinance. So the first step that is required here is to determine the type of use that is being applied for. Under the land use table contained in the town's ordinances, certain uses in certain zones may only be approved if they are approved as home businesses. Okay. So here, as was pointed out previously, equipment storage is a prohibited use in the rural zone.
But I guess that's my point, is that this seems inconsistent. It says home business is not a permittable use in the rural zoning district, but it is. But if you go to that chart, home business is listed as permittable in that zone. Equipment storage, trucks, 3 or more, is listed as not permittable.
Sure.
Those are two different things.
So the reason...
Not everything that's listed in that table is a home business.
Yeah, so the reason that the decision reads that way is that, so for example, a professional office, if you look to the land use table, you'll see that under the rural zone, there is a footnote that says approvable subject to it meeting the standards of being a home business.
Right.
So as a threshold determination, the board has to determine whether the use is one that could be permitted as a home business.
I'm not disagreeing with you there. What I don't understand is this conclusion that a home business is not a permittable use.
So it's a home business of a home business for equipment storage, trucks, 3 or more. So this is saying that we can't even apply the home business standards to an equipment storage use because that is flatly prohibited, whether it is a home business type use or not. whereas a professional office may be approved if it is determined that it meets the standards and definition of
Is that what
a
we're
home
hanging
business.
our hat on? Is that paragraph 1 under conclusions that says a home business equipment storage is not permittable use?
In addition to that, the board made robust findings in the previous section of the decision, including an analysis of the home business definition.
Well, they quote it. Do they analyze it?
So they make factual findings at the top of 23 that the proximity of the business located in the suburban zone to applicant's home located in the rural zone, the growth and scale and scope of the business has created an overflow that does not fit regarding commercial activity, warehousing, and trade parts in the rural zone. I think read as following that description of what constitutes a home business, I think it's reasonable to read that as the board interpreting those provisions and applying the facts here, which was their prerogative to do.
Well, they're basically saying it's going to be a warehouse, aren't they? The planning board is saying this is the real use of this is to store equipment.
Correct. And
They could have
ample.
worded the conclusion a little more artfully, I think is the chief's point. They're juxtaposing two different defined uses there instead of explaining that the proposed business is really intended to be something else, or we find that it's going to be used for something else.
I agree that the flow of the decision could have been made more artfully, but I do believe that the board here made a clear conclusion that the proper characterization of this would be an equipment storage use, and that use is not permitted as a home business, which was the nature of the underlying
So
application.
as we step through your analysis, the first step is to determine whether or not, in fact, it's a home business. And they've applied here for a professional office for licensed electrical professionals. And if that was simply a place with computers, telephones, fax machines, and they take orders, they dispatch electricians to sites, they do billing out of there, that's all okay so far, right?
Yes.
And suppose that they have a truck that says Jones Electric and they park it in the barn, still okay?
So this is, I think, the factual questions that the
Right,
board
that's-
has to
that's where
grapple
I'm
with,
headed, yeah.
right? And I think that the court case law is clear that determination as to whether the use meets the definition in the ordinance is a factual question. And
Absolutely. That's
one-
absolutely where I'm headed. I'm asking about that. So
Sure.
You probably might have said, if they have a truck that says Jones Electric, they're probably okay. And then I'd say, well, how about if you got a tool kit that he hangs on the wall? Probably still okay. What if they have 14 generators in there? Oh my God, no, that's it. So there's a continuum there. What is in the record that shows us that their planned equipment storage would land on that continuum to the place that makes it equipment storage as opposed to just ancillary to running the professional office?
So I would look to, this is an email, unfortunately I only have the record citation, but it's record cite page 70, which is an email correspondence actually between the applicant and the town that is describing the types of equipment that would be stored at the location. That would include electrical, mechanical, generator-related products that would be stored there for indeterminate periods of time. That same email exchange notes that some of the equipment that actually was being stored there was overflow from an existing commercial business across the street that is part of this electrical company that had to be moved due to space constraints.
So that email then was part of the record upon which the board made the finding that it would in fact be storage of equipment that reached that tipping point to make it a warehouse.
Correct, Your Honor. And they also heard, there was robust testimony from the abutters as well describing the scale of the use. It's worth noting, just for context, that the application came to the planning board after a notice of violation had been issued on this property related to the ongoing use. So the abutters and those who could see the property had ample opportunity to observe the nature of the use that was occurring here. I would also, so the appellants have noted that they have raised in their briefing before this court a question related to the delegation, to the standard relating to a home business being too vague or an improper delegation. The appellees would simply point out first and foremost that argument first appeared in the appellant's briefing, in their reply briefing below in the Superior Court. The standard is clear regarding waiver of issues even of a constitutional dimension being raised at the reply briefing level does not preserve that argument. Even if that argument had been preserved, as the court has already challenged in its questioning, the language here is definitional. It is language that is defining what, in fact, a home business is. This is very similar to language that would define what an accessory use, for example, is. This is simply not the same set of substantive review criteria that the court has said previously need to be tied to more quantitative language. So the appellee's position is that argument has been waived in any event, but here the threshold question was for the board to apply the definition to the facts. They did so, and they correctly determined that this business does not meet the definition of a home business.
I should know this, but I don't. Can you just clarify for me? Was there a public hearing held on this application?
There was.
And were the neighbors, the abutters, present for that meeting?
I believe they were, Your Honor.
Okay.
But Mr. Bedard's point is that without those 12 or 13 criteria, that's a pretty broad delegation of authority.
So the language itself may be broad, but it is at the same time specific. It is laying out that a home business is one that must be of a scale and scope that conforms with residential uses and residential neighborhoods.
Scale and character with neighborhoods in areas that are primarily residential. You don't think that's fairly broad?
I think that if it were a standard that was not definitional, or if it were something that were being applied in the conditional use or special exception context, the court has, looking at Casalca and some of the other case lines dealing with sufficient specificity, I think that is something that would be worth exploring. But here, again, the definition is what it is, and the board has to determine as a threshold matter whether that proposed use meets the definition in order to apply the substantive standards here. Definitions are, I think, by their nature, not necessarily quantitative. They are descriptive, and this definition is similarly descriptive in the same way that definitions defining principal or accessory use would be descriptive and not necessarily quantitative.
But the problem is, as Justice Mead was exploring with you, there's a scale here. It's at one end of the scale, it could qualify as a home business because it is in scale and character of the neighborhood if it's simply an office with a little closet. But if that closet gets bigger and bigger and bigger, or more items are stored there, then it becomes something else. And how can you determine that from that definition without looking at the criteria?
So I think you can determine from the definition directs you to look to the scale and intensity of the use in relation to other uses. And in addition to that, it points you to the substantive criteria that are required to determine whether or not the home business can be approved. In addition to that, and I think it's relevant to point out here, the underlying use, regardless of its scale and intensity, must be approvable in that zone.
Is that really what it is that the definitions of some of the other things, such as equipment storage or warehouses as being not permittable, help give shape, if you will, to the definition of what is an approvable home business?
They absolutely do, and the board below actually went through some level of that analysis and looking at really the commercial nature and the warehouse nature of this use, looking to the use table, observing that those were not permitted. I see my time is up. Thank you, Your Honor.
Thank you. And Mr. Bedard, I understand you have reserved some time for rebuttal. I'd be happy to hear your argument.
With regard to not raising this issue on scale and character as being part of what the planning board decided, you can just look at their opinion. They never decided that. They concluded one thing at the end. This is equipment storage. It's the way I read it. It's not allowed. So it comes in the reply brief because the town of Eliot used this as an argument. Superior Court did too. That's the first time it came up. That's why it wasn't raised before. And I don't think.
So from your perspective, they made a determination, the basis of the decision is that they made a determination that it's really equipment storage, which is not permittable as opposed to a home business.
That seems to be where they landed. They waffled all over the place with it's creeping from across the street. They mentioned this scale and character, but they didn't hang their hat on it. They went all over the place. Second point I will make quickly is if you look at the minutes, the abutters were there, but they just complained. One of the abutters complained about past usage. There's nothing there. It's helpful. With regard to what I think is key here, it's 163 and 164 of the appendix. It is an email from Karen Hughes representing Mark Moriarty and his wife. And they do list what kind of storage is going to happen here. But this is permissible. Most of it's permissible. I mean, I won't read it all because it would take a minute or so, but it's mostly paperwork. You know, there's computers, there's other things. There are generator parts. There's some of that mentioned there. Mike, but it's mentioned that there will be other parts there. But my point is what I made earlier, which is if it's a professional office and there's going to be some storage of equipment, which there isn't in any professional office. Lawyers are going to do it, plumbers, everybody's going to do it. They have a right and maybe an obligation to limit whatever storage they want. You can't take something that's a professional office and has some storage in it, because every professional office is going to have some storage in it under this definition for the town. And you can't just say, okay, we've decided it's all equipment storage. We're not going to consider professional office anymore. You grant the professional office, and if you wish to, you put conditions on limiting the storage. That's the appropriate. And I think you can rely on this email. I don't think it asks for anything unusual, but to the extent it does, it's still a professional office for an electrician. You grant it, and you make your limitations. Thank you.
Thank you. Thank you, counsel, for your argument here this afternoon. As is our usual practice, we will take the matter under advisement. We'll issue a written decision in due course. And with that, we'll be in recess on this matter.
All rise.
And good afternoon, you can be seated. And the matter before the court is BCD 2518, H.A.T or H.A.T LLC versus Greenleaf Apartments in Murray, Plum and Murray. We are being streamed on the web, both audio and video. I would ask counsel who are here and who are ready to argue to please introduce themselves for the record, together with the party you represent, starting with the appellant.
Good afternoon, Madam Chief Justice. My name is Jim Cloutier, and I represent H.A.T LLC, is what I commonly refer to them as. That's not technically correct, but it's convenient.
Good enough for us here today, right?
I believe so, yes, ma'am.
Okay, good.
Good afternoon, Meredith Eilers on behalf of appellee and defendant Greenleaf Apartments LLC.
Good afternoon, Russell Pierce. I'm here on behalf of the defendant, appellee Murray, Plum and Murray.
Thank you. And Attorney Cloutier, if you're ready to proceed, we'd be happy to hear your argument this afternoon.
Thank you, Madam Chief Justice, honorable members of the court. I'm glad to be here this afternoon representing H.A.T LLC, HAT as I much prefer to call them. That company is a Maine company. The initials stand for the first initials of the children of the owners. The owners are Portland residents David and Lori O'Donnell, married, and David's brother Patrick O'Donnell. They were involved in acquiring and trying to operate rental real estate in Portland, mostly, almost exclusively, and they concluded a contract to purchase the property located on Greenleaf Street in Portland in the waning moments of 2007, and the agreement was effective as of January 1st, 2008. Members of the court would likely remember that there was something called the Great Recession. It started just about the day that they closed on this property, and it certainly was one of the first challenges that the purchasers encountered. Frankly, the record in this case is enormous for the style of controversy that's involved. There's literally hundreds of pages of documentary evidence, and there were 4 days of trial. We come here because we think that there, under the rules of review, the conclusion of the judge below and the trial court below that my client was in default and subject to a just termination of their agreement rights is incorrect. In fact, we think the proper construction of the evidence indisputably indicates that they were not in default, and that the termination of the agreement was unlawful. The wrinkle in the case beyond that particular aspect is that at a point about probably a year and some months into the spring of 2009, having in mind that the 2008 year had passed, the operator of the Greenleaf Street LLC company, which was an
I see that the green light is on. The court here issued some fairly extensive findings. I guess this was a 4-day trial, so plenty of evidence went in, a lot of details and
Yes.
facts there, and the court has provided us with a fairly extensive factual record, so I don't know that we need to plow through that. But as I understand it, the real tipping point in this case, the key point, occurred on August 26, 2016, when the escrow agent went ahead and filed the termination agreement. And that was the end of it, because it was a bond for a deed, and they were entitled to recover the property. So the issue is, I think, as you're teeing it up, whether or not your client was in default. And the court here found there's ample evidence of innumerous, meaning too many to count, performance deficit by H.A.T throughout the period of time when it was in possession of the property. Any one of them would justify Greenleaf's election to proceed with a foreclosure of the contract. Couple of these items of default that I'll ask you to comment on is the fact that your client was way behind in the payments. Number two, he declared bankruptcy, which is a default event. And I guess I'll just leave it at that for the moment there. Let me just ask you, your client declared bankruptcy, right, during the course of this relationship?
I believe so, yes.
Yeah. And that's an event of default. That's what it says in the contract.
Yes, if it's claimed, it is.
Okay, so if 2 + 2 = 4, default, or bankruptcy equals default equals the right to terminate the agreement. Am I missing something?
Well, they never claimed that default as a basis for termination.
And any basis for termination other than non-payment requires a notice of cure.
That's true. I'm not going to say I have it at the top of my head how you would cure a previously filed bankruptcy, but I suppose there's some way to do it. One of the nuances here that may have restrained a claim of default in that circumstance is that the bankruptcy that was filed in and there was I was not the attorney involved at all, and I think a Chapter 13 was eventually filed in order to manage a specific debt, and that filing was done by an attorney at Murray, Plum & Murray, not Mr. Plum, and there was an agreement reached in the bankruptcy which reordered, at least temporarily, the ownership and operation of H.A.T.
Do you agree that under the contract, paragraph 14, no notice of cure is required for a default of non-payment under the contract?
I agree, that's what it says.
Okay. And so if there is, as a factual matter, non-payment in this case, the only way you get out of having the termination filed is either if the whole contract is somehow set aside as unconscionable, or I think you've argued that 6203F subsection 2 applies, despite the contract language.
Yes, I have to think that is over-aggressive drafting of the first order.
You agree if neither of those things are true? In other words, if the judge is finding that the contract was not unconscionable, is sustainable, and if we do not agree that 6203F applies, then termination without a notice of cure for non-payment.
Actually, no, I don't agree. The reason is because the circumstances, admittedly, there's an endless stream of circumstances in this case, but there were 3 casualty losses.
Let me just clarify one thing. My question was, if I finish it to be clearer, I didn't ask it well. You agree that if neither of those things are true, then they are entitled to terminate for non-payment if, as a factual matter, there was, in fact, non-payment, and that's a separate question.
Well, we do claim, I'm sure you know, from our filings, and I think it's pretty much, undisputed that the circumstances which we say give rise to a right of set-off under the contract exist, and that was because.
And as a result, from your perspective, they weren't in default for payment.
Sure.
So but that's the factual matter
Right.
I'm talking about.
And we think that circumstance, as it developed, also raises unconscionability issues. There was a free-floating $80,000+ credit that applied to, and appears by all textual information to be the property of my client. There was the payments you have in the record, they ran about $6,000 to $6,500 a month over the 8.5 years that H.A.T ran the property, and so $80,000, and the defendant, the appellee, always counted the August as the third payment that wasn't made. It was actually, according to my client's understanding, the second, because he paid January in the previous end of December year, and it was counted against, it was accounted in a different way by the appellee. But the real rub of the case, frankly, is that the relationship that he had, Mr. David O'Donnell, who was the manager, and Mr. Harris, who was a very gregarious and a friendly guy. He felt that he had a great relationship. If you looked at his testimony, and I'm talking about David's testimony, what he had to say about Richard Harris was as complimentary as you could ever see.
Well, Harris really helped. He helped him with the repairs, and Harris didn't want this thing to fail. He approached him on numerous occasions saying, let's work out this, let's work out that. I mean, it sounds like going along, Harris was kind of on your client's side.
Well, and that, you know, the background was that there were like 5 or 6 mostly larger transactions that Harris did at the same time in order to fund his retirement. And the only one left standing 18 months into the Great Recession was H.A.T. Everybody else had folded the tent. So, you know, that was part of it. And and I think they had some mutual interest too. We feel like the whole thing foundered when his cognitive illness became severe, and both his wife and his daughter, both of whom were trying to be active in the business, agreed that they habitually went to Florida for the winter, and at a certain point in Florida, things changed dramatically, and after that, he really was not involved much.
But by January 2016, there was a shortfall, as you know it, and I believe H.A.T advised Greenleaf, there's no way I can get this, you know, done in time, the time period you want to have it done, get caught up. So at that point, Greenleaf is in a position of saying, all right, well, you're underwater to this extent. You've told me you can't catch up with it. And then shortly thereafter, Greenleaf advised counsel that hadn't received a response, and they went ahead with the
Factually, I don't know where that factual understanding comes from. If you compare the year-end statements, which were produced every year, they're in the record, and there's an amortization schedule, at least for the first mortgage, in the exhibit. I think it's Exhibit 3. For a few years early on, H.A.T was a few $1,000s behind. Eventually, they were ahead, and then they stayed ahead. They were ahead the day that they pulled the termination papers out. Those.
Thank you, counsel.
Yes, thank you. Appreciate
You'll
it.
have some time for rebuttal.
Good afternoon. May it please the court. As I mentioned earlier, my name is Meredith Eilers, and I'm here on behalf of Greenleaf Apartments, LLC.
I see you went ahead and let the green light go on right away.
I did.
Can we look at 14 MRSA Section 6203F? And do you think, well, I guess there's 2 questions. A, would it apply, but for the contractual language, would it apply to this transaction? No. And if so, is it waivable? So you think it just doesn't apply?
I think it just doesn't apply.
Why do you say that?
I'm sorry?
Why?
Well, for a number of reasons. As you pointed out, subsection 2B states that this subsection applies only to contracts for the sale of residential real estate.
And isn't this residential real estate?
Not as to H.A.T. As to H.A.T, this was a commercial transaction.
Well, it wasn't owner-occupied, but if we look up above at subsection 1A, it talks about owner-occupied residential real property of no more than 4 units. So clearly, the phrase residential includes multi-unit buildings. And up there, it was specified owner-occupied, and here it's not.
I suppose that's obviously a fair reading of the statute. We would maintain that as to this specific transaction and this specific purchaser, this was not residential real estate. But most importantly, the second piece of this talks about when the purchaser is in possession of the subject real estate. Here, H.A.T was never in possession of residential real estate.
Is that because it's a corporation?
Yes, Your Honor. A corporation, or actually it's an LLC, but they, obviously, a business entity cannot have a dwelling residence, so they cannot be
But it
in
doesn't say
possession.
owner-occupied, it says in possession, as opposed to having vacated or given up the property or something like that.
It says possession of the subject real estate being residential real estate, but here, H.A.T was never in possession of a residence. H.A.T was in possession of a commercial property that it ran as a for-profit business entity.
If we thought, and I know you don't agree with this, but if we think that this subsection does apply, is it waivable by contract?
Yes, certainly.
And there was some pretty affirmative language in the contract.
Yes, for example, the waiver language was bold in all caps and specifically referenced this contractual provision.
Clearly a big waiver in the contract, but my problem is the second sentence of subsection B says all other transactions are governed by terms of contract. So doesn't that imply that this particular provision, if it applies, and I understand you don't think it does, is not waivable by contract?
No, because there's no constitutional right to notice an opportunity to cure. Maine has ample case law that entities can enter into knowing waivers of various statutory provisions. There's no law that says, there's no case law that I'm aware of that would say that this particular contractual provision is not waivable. But as to your initial observation about being in possession of subject real estate, I just wanted to note that for this to apply under these circumstances is contrary to so much other Maine law that specifically protects owner-occupied spaces. What benefit to a tenant? Most of the case law in Maine and most of the rules and regulations we have that protect owner-occupied spaces are because we want to protect an individual from unjustly having their home removed from them. The tenant is who lives in this space, not H.A.T. The tenant is who we would assume this statute was intended to protect, the individual who's living in the space, which is what we see in all of the other statutes and rules that are specific to owner-occupied spaces and foreclosure. A tenant doesn't get any protection if a notice is sent to its landlord providing an opportunity to cure. The tenant doesn't get the opportunity to participate in that cure. The tenant doesn't know about it. It wouldn't operate to offer any additional protection.
Was this statute intended to protect two savvy real estate operators with large commercial holdings throughout the city?
Of course not. If you extend
I'm just trying to move on to another topic, but you said
I
no, it
understand,
wouldn't.
Your Honor, but to your point, what if we have a large corporation that owns 500 units, and all of a sudden, just because those are residential spaces that other individuals live in, not that owner, now it's treated differently from something that's a commercial,
Right,
a more
I got
traditional
that point. Can I
commercial.
just ask you one
Yes.
other question? It would appear that the judge made a mistake about the insurance proceeds. He said that the insurance proceeds were to go to Greenleaf under the terms here. They do under the mortgage contract, the second one went around. Those proceeds under that section there would go to H.A.T. as opposed, I have this backwards, and there are two routes for insurance proceeds to go. One is in the original contract, and that one, I think, says that the proceeds would go to Greenleaf. And then in the other one, it said, sorry, I may have this backwards. But I think what the court did was it found this redirection of insurance proceeds, but misread it, and under the mortgage contract, it is the other way around, and insurance proceeds, I'll probably play it safe if you want to read it. It's at page 148 of the appendix, subsection C. And in this section here, the grantor, who is H.A.T, transfers and sets over and signs to the grantee, the Greenleaf, subsection C, all rights and proceeds of any hazard policies covering the improvements. So the court basically said, okay, it's all this stuff is going to go back to the grantee, meaning Greenleaf. But that mortgage and security agreement referred to certain properties, not these properties, but other properties that H.A.T owned and pledged for the refinancing that took place. So I think the judge got it backwards there.
This was addressed in the Rule 52 motion and hearing, and the judge subsequently issued an order clarifying that there was a second order that clarified that even if that mortgage language doesn't apply, there's ample other evidence in the record that makes it clear that that insurance check should have gone to Greenleaf instead of H.A.T. And the real reason for that is Greenleaf is the entity that paid for all the repairs. The parties had an agreement. While all of this was happening, there was a burst pipe event. H.A.T didn't have the funds to make any repairs. Greenleaf had the funds and was still trying to, as you mentioned, limp this relationship along and help him out. And so Greenleaf agreed, I will pay for the repairs. Greenleaf processed the insurance, so it only makes sense that Greenleaf would get that back. And in fact, Mr. O'Donnell, when testifying on behalf of H.A.T at trial, agreed that that made sense under the circumstances.
Can I ask a question? So my understanding is that part of plaintiff's claim is that essentially Greenleaf pocketed some approximately $80,000, I don't remember exactly what the number is, of insurance proceeds. I understand the justification that they spent Greenleaf spent more than that in order to try to repair. But if indeed plaintiff was correct and that $80,000 plus or minus should have been credited to H.A.T, would that mean H.A.T is not in default from payment terms?
Well, first, we don't see any basis in the record to conclude that money would ever, under any circumstances, go to H.A.T, because you have to read the contract as a whole. H.A.T had a repair obligation, and then the insurance proceeds.
I understand why you think it doesn't, but my question is, would that cure any payment default if indeed it had to be credited?
The court's findings at trial would disagree. So first of all, there was a judicial admission that that payments were due.
I understand all of that.
H.A.T certainly had already basically conceded the point that they were in default. That was in the complaint, and then also there was ample evidence in the record, in the exhibits and testimony at trial, that H.A.T considered itself, frankly, to be in default.
Was it in default by more than $80,000? In other words, if that money were credited to it, would it still be in payment default? Because any other kind of default requires a notice.
Well, so the only way for that to be credited would be to trigger the set-off provision in the contract. Is that what you're talking about, I assume, Your Honor? So there's a number of things that have to trigger the set-off. So in order to set off, the first thing is that
You don't want to answer my question. Would they still be in default if the $80,000 was credited to them? Would they be in payment default?
There's no avenue to credit it to them because they can only credit it through a provision in the contract, which for other reasons wouldn't apply under the circumstances. Sorry.
Thank you. Attorney Pierce?
Thank you. I'm here on behalf of Murray, Plum & Murray. The law firm, Greenleaf's law firm, was named as a defendant when the case was commenced. We brought a motion to dismiss for failure to state a claim, and the motion to dismiss was granted. Under Rule 55B, there was no direction of an entry of final judgment at that time, so the dismissal in favor of the law firm does not become final and appealable until all of the claims against all of the parties are resolved at trial. So we're here back in the case after 5 years. Our primary, I think, position on appeal is that if the main case against Greenleaf is, if that judgment is affirmed, there would be no basis to, there would be no independent claim that H.A.T could pursue against the law firm. And in page 19 to 21 of our brief, we kind of explain the number of ways that could occur. I think the most logical way of treating it would be if there's an affirmance of the judgment in favor of Greenleaf, then the court need not reach the appeal as to Greenleaf's lawyers, because the factual findings and conclusions of law inherent in that affirmance basically would preclude any further claim against the law firm. The one other point that I think is important here is the way the claim was pled. The First Amendment complaint, upon which we moved to, we filed the motion to dismiss.
Was the contract attached to the motion to dismiss in the termination documents?
No, it was not. Well, we attached the contract documents, yes.
Were they attached to the complaint when the complaint was filed?
I don't believe they were, no. I'd have to go back to check, to be honest with you. I don't think they were. But if they were, we wanted to make sure the court had a complete set of the operative contractual documents.
At what point does it convert into a motion for summary judgment rather than a motion to dismiss under 12b-6?
At that point, it does not, under the rule that is now, the procedure rule that's been applied commonly in Superior Court as well as in federal court. When there are operative contractual documents, if the claim is breach of contract or other related requests for relief surrounding those operative documents, the court, as long as there's no dispute about the authenticity of those documents.
Was there any dispute below?
And there was no dispute here. So the court, whether it's phrased as taking judicial notice or...
I think under Moody,
right.
blessed that.
It's commonly done, and it makes sense, not just in contract cases. We deal with this in defamation cases too, where the statement of the claim is the inherent document that needs to be reviewed, and the courts will readily look beyond the pleadings for the purposes of making sure that there's a complete record on the statements or the operative contractual documents if it's a contracts case. And so that was what was done here. There was nothing irregular about the proceeding. If there had been, the plaintiff could have raised that issue with the trial court and said, wait a minute, I'd like to have this converted to a motion for summary judgment. That was not, the right was never exercised, that request was never made. And really now in hindsight, after a 4-day trial, none of that would have made a difference, because all of the factual issues, to the extent there were any, that would have been the basis of plaintiff's request to convert to a summary judgment motion were actually tried. That was part of the trial. And so at this point, again, there's a mootness issue involved in that. So, thank you.
Thank you. And Mr. Cloutier, I think you reserved 3 minutes for rebuttal.
Thank you, Your Honor.
Do you agree with the assertion that if we were to affirm as to Greenleaf, that really essentially moots or leads to an affirmance of the dismissal against Murray, Plum, and Murray in any event?
I have to admit, I'm pretty unsure about that. I think the issue probably is one of collateral estoppel. The gravamen of our complaint related to Murray, Plum, and Murray is that they anointed themselves as escrow agents at the same time that they
And there
were...
was a hold harmless provision in the escrow agreement.
Oh, there certainly was. There were, yeah, no question about it. But still, negligence, their obligation under the progressive case and under the, the guidance we have from the ethics committees that we have, seems to me like it creates a problem that it may be moot. I can't say that it isn't, but as I sit here after 4 days and thousands and hundreds of pages, at least of documents, it does occur to me that by short-circuiting an actual tribunal that would be able to make a fair decision and releasing those documents, which frankly were sufficient to convince people that paid rent and people at Portland City Hall that H.A.T was out, that effectively terminated the contract. It was effective in that way. But frankly, whether that would create an independent claim that the escrow arrangement had an inherent conflict of interest.
Is that the essence of your claim?
That was at a motion level. I'm sorry, Judge.
Is that the essence of your claim against Murray, Plum, and Murray?
Yes, it
having to
is.
do with
We certainly agree you can't
escrow?
sue somebody else's lawyer under usual circumstances. But when you put yourself in the middle, you're in the middle. And there was $500,000 of equity at stake when this was blown up. I'll finally say, I think the supposition that there's a new commercial intention or use or possibility that negatives some of the application of, I'm going to get the number wrong, section, I think, 4306 or something, F. I don't think that is a viable reading of that statute under any circumstance. So, thank you.
Thank you. Any other questions? There don't appear to be. All right. Thank you, counsel. Thank you for the argument here this afternoon. We will, as is our usual practice, be taking this matter under advisement and issuing a written decision in due course. With that, I believe we're in recess for the day.
All rise. All persons that may be further is before the Honorable Justices of the Supreme Judicial Court, sitting as law clerk in the hands of the clerk, and give their attendance here at 9 o'clock tomorrow morning as this court now stands adjourned. God save the state of Maine and this honorable court.